Hello, friends and neighbors. Dr. Ken Berry. Today I'm wearing my farmer's hat. I'm Rancher Berry to you today, and I have a great guest on. As Nisha and I have been building out our homestead here and our regenerative farm and ranch, we keep talking about self-defense. We all are interested in defending ourselves and our family. But then when you start to accumulate a lot of livestock, a lot of produce, you start to think, well, what if somebody tries to steal my sheep? Do I have a right to protect my sheep, aka property, by brandishing a firearm, by using deadly force? What's the law in Tennessee? What's the DA think about that? And probably most importantly, what's the deputy sheriff going to think about that when they get there? Because if they arrest you, then that's a whole nother can of worms. Whereas if they don't arrest you, then that's much better for you. So I've got a great guest, I think one of the leading authorities on Second Amendment rights, not only nationally, but in Tennessee, and then just a constitutional scholar. This is C. Richard Archie. Welcome, Mr. Archie.
Thank you, sir. Glad to be here today, and hopefully I can shed some light on the issues that you've been concerned with and mentioned.
So I know you can shed some light on it because this is what you eat, sleep, and breathe. I've talked to this man multiple times about Second Amendment stuff, but also just about general constitutional questions. And I have never met another living human who knows as much about the Tennessee Constitution, about Tennessee statutory law, about the U.S. Constitution, and everything that goes, including attorneys general opinions about these things, because sometimes that applies as well. So if you're watching and you know anybody in Tennessee who owns a little micro farm, a big ranch, they probably would like to watch this, even if they don't know they need this information. So please share this on your social media. Text somebody, email them, WhatsApp them, and say, hey, they're talking about whether you can use a firearm on your property in Tennessee. You might want to watch this. Mr. Archie, it seems like, as a common sense Tennessee boy, that there shouldn't be a lot of kick up about this topic. When I was in junior high, if another kid insulted your honor, you can meet him out back behind the field house after school, and y'all could punch it out until we figured out who was right and who was wrong. But we're all grown-ups now, and we have to abide by the law in letter, if not in spirit, correct? And so first of all, I want to ask you this question, because I know we've got a lot of people moving in Tennessee from other places, and I'd like to welcome them if they'd like to keep my Tennessee and not bring their California with them. Then I would love to welcome them to Tennessee. But a lot of people believe, because they've been trained to believe this, that if there is an intruder, if there's a robber, if there's a break-in, if there's some kind of trouble on your property, you dial 911 and you sit there and I guess take whatever's meted out to you until law enforcement gets there. What's your thoughts on that? Is that a good idea or a bad idea? If so, why?
Well, it depends on whether you like being tried by 12 or carried by 6, I guess, is the answer there. Here, let's start with the original premise in Tennessee. You have to understand that we are, in fact, coined as the patron state of shooting stuff.
That's right.
And so if you look back at Tennessee history, every time that there's been a scuffle for liberty in the annals of history of the United States, the people that live, eat, and breathe this soil right here have been invested and involved in a big way. In the Revolutionary War, when Cornwallis sent his little henchman, Mr. Patrick Bulldog Ferguson, down into the southern tier states, because what he wanted to do is put a stop to the rednecks down here, because if you understand, in the Appalachian Mountains, most of the people that inhabited them at that time were Scotsmen and Irishmen. Yes. And there was an absolute animus between the British and the Scots anyway, because they'd always been treated bad. Absolutely. So they sent Ferguson down here, and anybody that has watched the movie The Patriot, if you remember this deal about, well, anybody that picks up arms against the crown, we're going to hang him and lay waste to his land with fire and sword. That's what Ferguson put on a letter, and he sent out to all the people in what was then the hinterlands of North Carolina over here in what is now Tennessee. And you had a group of individuals over here that just absolutely weren't going to put up with that. And so they formed a coalition of what was called the Over Mountain Men. And so they got together, pooled their resources. One of them actually, in fact, mortgaged his farms. John Sevier said, I tell you what I'm going to do. I'm going to go ahead and put my farm up, and I'm going to buy beans and fat back. And with some of the other guys, Isaac Shelby and Carroll and a couple of more, and they had some folks from Georgia and a few from Kentucky, but most of them were from right here on this soil in Tennessee. And so they marched over the mountains, and they ran Ferguson up on top of a hill in South Carolina, Kings Mountain. And in about an hour and a half, they decimated those forces, shot him off his horse and cut his head off. And then they came home because what
and they had a significantly smaller force than he did, correct?
Yeah. See, we had about 800 guys and they had over 1,500. And the whole point of the matter was we were fighting for liberty and for freedom. And you've heard the old saw about beware the man that just wants to be left alone. That's all they wanted to do was just be left alone. Because what happens is when he steps outside the bounds of what he lives and what he does at that point, he knows that his life that he has led up until that point is now forfeit. And so he fights with a violence that nobody can understand. And what you do is you keep poking that bear. And what will happen is like they say, if you mess with the bull, you get the horns. So that's what Ferguson got. And Thomas Jefferson said it was the turn of the tide of the war in the Revolution. It was absolutely necessary because those rough frontiersmen with their personal rifles, this wasn't the army, it wasn't the militia, it was a group of guys that I don't think you're going to do that, just got together and decided they were going to do something about it. And so they marched over to South Carolina and took care of business, and then they came home. Now, John Sevier was also the first governor of the state of Tennessee, and people like to say that he didn't have anything to do with writing the Tennessee Constitution. However, he sat on the outside while Andrew Jackson and some guys who are far better known take credit for it. But some of the annals are in there were absolutely brought to us by John Sevier, and one of those was the right to personal firearms, because he understood that it was necessary if you were going to go against a tyrannical government that you couldn't give your weapons up, because that's what got that scuffle started at Kings Mountain. Was Ferguson said, y'all got to lay your guns down, we're going to come after them. And they said, I don't think you're going to do that. So from that to Andrew Jackson and his guys, the volunteer state where we get our nickname. Everybody wants to say, I gave a speech the other night to a group of individuals who were retired military. And I asked everybody if they understood where we got our nickname. And they said, yeah, it was during the Spanish-American War with Texas. No, it wasn't. It was when the governor, Willie Blunt, stood on the courthouse steps in Nashville and asked for volunteers to go with Colonel Jackson down into Alabama to fight the Red Sticks or the Creek Indians. They asked for 2,500 and over 5,000 showed up. And so what they did was they went down to Horseshoe Bend and they defeated the Red Sticks. And then they turned around, part of them did, and marched all the way to New Orleans because they had found out that the British were going to disembark the finest soldiers that they had at the port of New Orleans down there. And so Carroll went back up into Tennessee, got more provisions and people, and he's one of the captains that he had. And he came down the river on a set of flatboats, and Coffee marched across from Jacksonville, Florida, all the way to New Orleans. And when the British got off of the boat, they ran into the buzzsaw that was Tennessee. And once again, these were people that were not Army. There wasn't any, how shall I put this? They weren't paid soldiers. They were just citizens that decided they were volunteers. And that's where we got the name the Volunteers, because we went down and defeated the British at the time. And once again, the reason that we were able to sustain our nation in 1814 and win that fight was because we were expert marksmen with our personal rifles. So all that being said, the original Constitution in 1796 of Tennessee, the Second Amendment analog, and people get on me because they say I try to talk over their heads. I mean, the thing that's just like the Second Amendment, okay?
Mm-hmm. Mm-hmm.
Right. What it said was the free men of this state have a right to keep and to bear arms for their common defense, period. There wasn't any of this mess about the General Assembly got any power to do anything with it, because the power is inherent in the people and not in the legislature. The legislature is a group of servants. The Constitution of the state of Tennessee is simply a contract amongst the people. And what it does is it presents a set of written hiring practices for the servants that we need to do the business of our government. Because Article 1, Section 1 says all power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, and happiness. For the advancement of those ends, they have at all times an unalienable and indefeasible right to alter, reform, or abolish the government in such manner as they may think proper. Now, that's on us, the people. It's not on the legislature. They're just supposed to do what the Constitution allows them, because we gave them a job description. The Constitution says how old they got to be and where they got to live and what their delegated powers are. And so they can't step outside the bounds of those delegated powers. The most important codicil or statute in the Constitution at the time was Article 10, Section 4, that said the Declaration of Rights hereto annexed is declared to be a part of the Constitution of this state and shall never be violated on any pretense whatever. And to guard against transgression of the high powers which we have delegated, we declare that everything in the Declaration of Rights contained is accepted out of the general powers of government and shall forever remain inviolate. That was in 1796. In 1801, the General Assembly passed the first law, said you couldn't carry a handgun. Now, that's not in the delegated powers that they were given, but what we find out is that General Assemblies and legislators intend to do stuff that would probably make you want to shoot them. So what they do is they try their dead level best to disarm as many people as much of the time for any reason as they can. And so what they started at that point was saying you can't carry a handgun because you could stick them underneath your coat and slip into the legislature and pop one of them, right? Okay. So they said that was illegal. You couldn't do that. And in 1821, it even got worse. And then it's gone all the way to 1870 when they finally said, hey, you can't carry no firearms anywhere for any reason at any time, except that it was still lawful then for you to carry a long gun. And I can prove that because the Heller case, the federal Supreme Court case, SCOTUS, in 2008, quoted a case from Tennessee, Andrews v. State in 1871, and said, hey, wait a minute. You know, the General Assembly has passed this law, and they got the people to ratify, saying they've got the power to regulate the wearing of arms with a view to prevent crime. They changed that in 1870. All right. Got the people to vote for it. I don't know why, but anyway, they did. They gave up their rights. And so what it boils down to is the General Assembly has got to, if they're going to pass law restricting your ability to enjoy the rights and privileges in the Constitution, have to prove that it reduces crime. And I've asked this question in committee 1,000 times. What law does the state of Tennessee's law enforcement agencies, whether that be TBI, Department of Safety, the state police, Tennessee Highway Patrol, the sheriff's department, or the city police, what law do they enforce that keeps a criminal from using a gun to commit a crime? And nobody's been able to answer me. So now what we've got is a situation that most people need to be aware of. We have a statute in our code annotated 3917-1307 A1 that says it's an offense, and that means a crime, to carry a firearm or a club with the intent to go armed. Now, I write a Substack, and if people really want to get into the nuts and bolts and the basement of this whole thing, I describe this in lawyer terms and try to get it out where people can see it. And what I do is I actually use the vernacular of the Supreme Court of Tennessee, the Supreme Court of the United States, the law cases that are going on in Tennessee, and try to get it to where people understand. But let's just be real simple about it. It's a crime for you to carry a firearm in Tennessee.
And I'll link to your Substack down in the show notes. I'll put a link. Okay.
So, and there's a lot of them. The one that I would say is the most important is dig back into the front end of when I started this and read the 4 pillars of the Second Amendment. That'll open your eyes. But anyway, here's the law in Tennessee. It's a crime for you to carry a firearm. And everybody says, well, wait, I've got a handgun carry permit. Yeah. And what that is simply a defense against prosecution, because it's still a crime. And if you have, and that's if you've got the enhanced. Now, the enhanced carry permit is very akin to going to the grocery store now and buying a box of cookies. And what used to be 4 years ago, there was 120 cookies in there for $2.12. Now it's $6.50, and there's 50 cookies in there. It's new and improved, right? That's what the enhanced carry permit is. When the NRA came into Tennessee and convinced an individual who was a legislator from West Tennessee to propose and carry the concealed only permit class of permits, they changed up what we have always had as a handgun carry permit that says you carry open or concealed. So they called it then the enhanced handgun carry permit, and then the new one was called the concealed only. And that you didn't have to go take a class. You could do it online, which means you could talk somebody else into answering those 4 questions they got. And you didn't have to prove that you knew how to use your firearm, and you didn't have to shoot for score. And so a lot of different states would not allow reciprocity with that, because they require people to actually have a hands-on knowledge of their weapons, and they need to be able to prove that they're proficient. Because when you start busting the cap out there in a store, you want to be sure you're not shooting the people over on the right and left side. You got to be able to aim at your target and hit it. So anyway, we've got 3 different classes of so-called permits now. We have the enhanced carry permit, which is the one that takes an 8-hour class. And then you have to prove proficiency with your weapon, and they call that enhanced. But by the way, they don't put enhanced on that permit card that they send you. I've never understood that. I just got mine renewed the other day, and the dang thing's pink. It's not even red like Tennessee driver's license ought to be. I don't know whether that's some kind of pride thing they've got going, but a pink handgun carry permit, I wasn't real happy with that, but they didn't ask me, and they never do. The second type of permit is a concealed only, which you can get online, and you got to pay a little bit of money to the state for that. And then the third is what we got in 2022 that Governor Bill Lee proposed, that they term constitutional carry, which is anything but. What it is a set of permitless carry rules for certain people, certain places, sometimes. And so it is not constitutional carry, because guess what? It does not protect your ability to carry, and that's a long gun. And remember, Tennessee is, in fact, a patron state of shooting stuff. And anytime you see a picture of David Crockett or Sam Houston or any of the guys that marched over the mountains into East North Carolina or Western North Carolina, South Carolina to fight that battle, they all carried long guns, because you don't go to war with a handgun. It's
right.
The old saw about don't carry a knife to a gunfight. Well, that's what the state of Tennessee wants us to do, is to have to carry and you can't carry a club. And by the way, here's something people need to understand. Our codes say it's okay for you to carry an empty firearm, whether it be a long gun or handgun, permit or not, doesn't make any difference. But you can carry a rifle or a shotgun as long as you don't have ammunition within reach. But if you grasp that bugger by the barrel and decide to swing it to save your life, you've just become a criminal, because you also can't carry a club in Tennessee. Says so right there in 1307A1. So the laws in Tennessee are just a jumbled mess of nastiness. And it's that way because then you have to understand the person that fills out the charging document for you if you commit a crime is the DA of the district, judicial district that you're in. They have what is termed judicial, what's the word I'm looking for? And sometimes but it's in other words, what they can do is they've got the ability to say whether they want to charge you or not.
Right.
And so if in fact that's the case, and you go to Nashville and you use a firearm to protect your life, you're liable to wind up charged with 1st-degree murder. Where if you do that in Madison County with Jody Pickens down here, he's going to look at the facts, and if you're protecting your life, you're not going to be charged. But that judicial discretion, prosecutorial discretion is the word I was looking for. Our DAs have that, and so there's no codified set of stuff across the state. If you are forced to use a firearm in defense of your life or someone else that you're responsible for, they're not going to tell you. They don't have to look at it and say, well, was that self-defense? There is no designated fact that says they have to investigate that. There is no charge to them. They have the discretion to say, well, maybe and maybe not. And so here we are left in limbo again, because we've got legislators that have no spine. And what they did was they took away from the original construct of our 1796 Constitution, said you got a right to use a firearm to protect yourself, period. Now, part of the crux of the matter that I think you wanted to talk about is farmers and people who have property out there on the farm, and can you legally use a firearm to protect from loss of that? And the short answer in Tennessee is you cannot. Whether it is a handgun or a long gun, it doesn't make any difference. Now, 1307 says it's a crime to carry any firearm with the intent to go armed. And that's been defined, the intent to go armed, which is a very loosey-goosey term that I've never seen really defined anywhere. And you know me, I've done the research, and I can't find a code section that says what it is.
Well, I mean, the wording, what it effectively means is that when the investigating officer gets there, it's his judgment of what your intent was, which means that the officer is effectively tasked with reading your mind. What was your mental internal intention carrying that gun? Was your intent to go armed, or did you have another intention? Why would the legislators ever leave that in such an ambiguous, basically indecipherable way? Just imagine a deputy. I'm sitting here, I see a guy out there, he backs his trailer up, he's trying to catch my sheep. I call 911, and then I'm like, okay, can I go over there with my shotgun? Can I walk out in the pasture and yell at him while holding it? Not pointing it at him, not shooting it at him, just holding it, maybe racking it, saying, hey, what are you doing? Get off my property. Have I just committed a crime? When the deputy gets there, because he was taking a break, he was enjoying his beverage, and now he's got to go out, he's got to call, he's got to come out there, so he's not going to be happy to begin with. He gets there, and there's the guy holding one of my sheep. I'm holding my shotgun. I haven't pointed it at him. I haven't threatened him with it. I'm just holding it, which I think probably classified as threatening him with it. I've got to depend on that deputy reading my mind and knowing what my intention was. Is that correct?
It's even worse than that, because you can't have your shotgun or your rifle out there if it's a human being. If you look at the code section under 1308, Bing's 1307 says the carry of any firearm is a crime. Then we go to 1308, which are the defenses. And they'll list the permits under 1351, which is the enhanced, 1366, which is then going to be the concealed only, 1307G, which is the governor's supposed constitutional carry. All those are listed as either defenses or exceptions. But you know what? The only time that you can use a long gun, instead of just a handgun now, but a long gun, even on your own property, if it's a person involved, is if they've already threatened, if a reasonable person at that point would perceive that their life was in danger or that they were liable to be severely injured in the contact. Now, if the guy is stealing your sheep, you can't even display a shotgun. Not by law.
I can't even take it out in the pasture.
You cannot.
I need to leave it in the house.
That's correct. Now, you can carry a handgun if you've got a permit, or, under the either of the other two, the concealed only or the governor's so-called constitutional carry, you could carry a handgun out there, but you must not pick it up and display it, because if you put it in your hand and you display that, that's now called brandishing. Right. And so what you've done is you have threatened their life with deadly force, whether you use it or not.
Even if you don't point it directly at them.
That's correct.
Holding it.
That's correct. Now, again, you're going to get down to that discretion. If your sheriff's deputy coming out there goes to church with you and he knows you and he knows that this individual out there that was on your farm was just trying to steal your sheep and you didn't try to hurt him, then he may not arrest you for that. But if it's somebody that's on the other side of the political spectrum, if he dated your wife in high school and he don't like you because you won out, guess what you're doing? You're going to jail.
Yeah.
And the
And
whole
then,
point of the matter is they can do that because they
right,
have the discretion to make that choice. It's not
right.
cut and dried, and you have no protections in Tennessee from that. And the fault lies completely with our legislature.
So I have to depend on the deputy, first of all, his discretion and his ability to decipher what my intention was, number one. But then if I do get arrested, go to jail for brandishing, then I have to depend on the discretion of a second individual, the assistant DA, who will decide, are we going to press charges or not? So if I'm having to depend on the independent discretion of two different government employees, that doesn't really sound like a Second Amendment state to me.
No.
Is Tennessee not a constitutional carry, Second Amendment friendly state?
Under no circumstances is it. And that's the problem that we face. These people moving in from, I'll give you a for instance, Pete Hegseth, who is now the Secretary of Defense. He moved into Tennessee from New Jersey, and he came and he spoke at our TFA event last year. And so when I sat down at the table with them, I'd never met him before, but I understand he's a pretty good guy. So I spent about 30 minutes with him prior to talking about his kids. And he said, I moved in here from New Jersey, and I thought I was moving to a free state until I found some of your buddies up there in Sumner County that explained, no, you have no right to carry a handgun in Tennessee or a long gun, period, at all. In fact, it's a crime for you to do so. And he thought, what in the world? He just knew that he had come to the land of liberty. And what he found out was it is this whole dang rugby scrum of problems, and that you're going to have to depend on everybody else deciphering what they think is the correct thing. Let me explain a couple of issues for you. In that Heller case in 2008, them talking about the Andrews v. State case that said what the General Assembly just did is unconstitutional. And by the way, you can still carry a long gun. It was lawful in Tennessee from 1796 until 1989 for anybody who could possess a long gun to carry them for all lawful purposes. As a senior in high school in Milan, Tennessee, over here in West Tennessee, in my pickup truck one day every morning when I went to school were two different firearms. One of them was a 30-30 deer rifle, and the other was a 12-gauge shotgun.
Yep.
And I was able to park on the school parking lot with those firearms in my vehicle, and nobody thought anything about it. It was completely legal until 1989, when the Democrat governor at that point and his Democrat henchman in the House, Jimmy Nafee, all decided, you know what? We just been letting these rednecks walk around with these shotguns, and they're dangerous weapons, which is untrue, because every weapon, by the way, is dangerous, and one's not any more so than another. And here's a fact: in Tennessee, more people are killed with hammers every year than with shotguns and rifles combined. Mm-hmm. So we're gonna register hammers. Hands and feet kill more people than rifles. And just all of a sudden, you got to think about the term dangerous. If you go back to the Supreme Court cases, they say everybody's dangerous. Everything is dangerous. For it to be banned, it must be dangerous and unusual. Now, those of us who had children coming up during the Schoolhouse Rock, we know what the conjunction junction is. Catano, which is a Supreme Court case in 2016, built on the statement of in common use, and you can't ban it unless it's dangerous and unusual. And they mandate that to ban an arm, not just a firearm, but any arm in the United States, it has to be dangerous and unusual. And so with that being said, if it's something that's in common use, guess what? That's not unusual anymore. And they gave us a number for the metric to decide what unusual was, because they said there's less than 200,000 stun guns in private hands in the United States. And guess what? That makes them not unusual.
And in the Catano case, it was a stun gun or a taser that was at issue. And that's why
correct. That's right. And so what they said, that's an arm. Because if you go back to the Second Amendment, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, originally in 1870, when they passed this new deal, it said the intent to go armed clause, and now what it says is just can't carry firearms or clubs. Originally, they said you can't carry a firearm, a knife with a blade of over 4 inches, or a club. And then about 10 years ago, maybe 12, I'd have to look it up because I don't keep those things in front of me. I got too much other stuff that I've got to be able to recall. But Mike Bell, who was the chairman of the Senate Judiciary Committee, ran a bill that removed knives from that dangerousness in Tennessee. And I don't know who came to him and said, I think it's okay to carry switchblades or swords. But now it's okay for you to bear a switchblade or a sword. It's lawful in Tennessee
for self-defense.
Yeah. And so, and you mean, and again, if you're carrying it with no intent to do harm, they can't say anything about it. And the only time then they could charge you with carrying a knife if you use it. Why don't we treat firearms the same way? If you look at a case, the DAs, if they're going to charge somebody with running over you with a vehicle, they have to look at that and say, was there any mens rea there? In other words, evil intent. Did grandma not take her meds that morning and go to sleep while she's driving and she runs over and kills you? Well, guess what? That's just accidental homicide. If she had her meds that morning and she didn't like you and she sped up to run over you, that's mens rea. That was with evil intent.
Yes.
And so if we look across the board in the United States and Tennessee, it's always been a decision, was their intent. And what is that intent? You couldn't have a crime unless there was evil intent, unless there was mens rea. That's not the way they treat firearms. It's a crime for you to possess and carry that firearm. And all you had to do was intend to be armed. And so my question to them has always been, well, why would you stick the bullets in that rascal and put it on your hip if you didn't intend to be armed? That is the most ludicrous, ridiculous set of words that ever came out of a General Assembly, but they hold on to it like it's the Holy Grail. We have tried time after time after time to get that stricken, and they just absolutely will not do it. The leadership in the House and the Senate runs from that like scald apes, man. They're just not going to touch it because I don't know who pays them to keep that on the books, but that's not the way that we were fomented to be as a state. We had liberty and freedom at that point, and what we've got now is a bunch of cull legislators, and you got some good ones. I've got a friend, Chris Todd, gets mad at me every time I dog cuss the General Assembly. He said, there's some of us that are trying, and that's true. And I have to give them props for that. And I help them and I send them money and I talk nice about them. But as a general rule, the people who are responsible for keeping us in our place is the General Assembly. Because our division of power in the state of Tennessee, and by the way, the Constitution of Tennessee, when they read that thing in Washington, when Andrew Jackson carried it up, Thomas Jefferson looked at it. He said it was the least imperfect and the most Republican of all the documents that he had seen. And then George Washington carried it into Congress the next day, and he told him, he said, look, man, these guys down here, number one, they've been fighting for us all along, and they're the right kind of people, and y'all just look at this Constitution. It's great. We didn't even get a chance to vote on it to ratify it as citizens of Tennessee. Right. They installed us as a state that day, June 1st, 1796. We never even had a vote on the Constitution. That's how good it was. Now, the first thing they did was start trying to tear it down and change it into something that it wasn't.
Of course. Now, let's go back to our guy. He's got a little 5-acre farm. He got some chickens and sheep, and he hears somebody, let's say it's dead of night, and he hears somebody rumbling around through his storage shed. And what can he do in Tennessee currently? He calls 911, which I think that's wise for anybody to do, to get them going. But what I've been reading, Richard, is that the response time, whether it's urban, suburban, or rural, can be anywhere from 15 to 35 minutes.
Yes.
A lot can happen in 15 to 35 minutes.
I make the statement that that's why they carry chalk and yellow tape, is to draw circles around the body and to keep the press from walking over and stepping in the blood. Because the average crime takes about 2 minutes. And if it's 20 before you get there, What you're doing is you're investigating the crime. And by the way, so that everybody understands that, there is no statutory or constitutional responsibility for any officer of the law, any entity of government to be responsible for your security or safety.
So
If
let's
in fact,
put that down, because that's very important. A lot of
yeah,
people do not understand this. Even though on the deputy's car it says protect and serve, you're telling me that they have no legal duty to protect you, to protect your safety, to protect your family, that there's literally no regulation that says you must protect this family.
all right. You're correct on that. And those words they got printed on the side of the car is marketing, is what it is. They're trying to sell a product. Okay. Sheriff's Association like to send you the little thing once a year and say, send me your $35 and I'll put you a sticker you can put on your back window. Like that's going to keep them from writing you a ticket for something. And it's not. It's just, again, it's marketing. You have to understand that there is no obligation. If you go and look at the sheriff's oath in Tennessee, it says that what they're supposed to do is to keep general peace and to defray riots when they find them and to arrest criminals when somebody else tells them that they are. But you know what they're not charged to do is to provide security or safety for any individual who's not in custody. Now let's think about that.
Now, wait a minute. I want everybody watching this to hit the thumbs up to let YouTube know this is good content. But I want you to tell me in the comments, did you know that? Did you know that the deputy, the policeman, they have no constitutional duty to protect you as an individual citizen? Did you know that? Yes or no? Be honest in the comments. Go ahead, Mr.
All right, so here's the facts and the way to prove that. So you decide in Jackson, Tennessee, that you're going to run down to your buddy and you're going to go fishing at Tennessee River, right? At 3 o'clock in the morning, he calls and says, hey, I'm out of sinkers. Can you stop at Walmart and get some sinkers on your way down? So you pull into Walmart 3 o'clock in the morning, you start walking across there, you get your sinkers and you come out and your car's gone. It's not there anymore. It's been stolen. Do you get to go to the Jackson Police Department and have them write you a check for your car? They're not responsible for it. They're going to look at you like you got two heads and say, no, dude, that's what your insurance is for. Now, same trip, you're walking in there and say a couple of thugs decide they like the wristwatch you've got on. Say, mister, can I have that watch? And you say, well, no, that was a present. I'm not going to give you my watch. Well, we're going to take it from you. And they take a club and beat you to the ground and steal your watch and knock your teeth out. And so doing, does the Madison County Sheriff's Department have to write you a check to get your teeth fixed? Absolutely not. Can you sue them because you were assaulted? No, you cannot. The thing that I try to tell most people is you need to understand you're your own first responder. And if you don't know that, you got soft spots in your head and you need to wake up. Now, the government doesn't want you to protect yourself against these people either. They just want you to be a victim. Because if they didn't want that, they would change the laws and allow you then, again, what I said a while ago, for any person who is going to use, and there are 5 places, let's get this down right quick. It's important. 5 places that you're presumed that you can use deadly force or the threat of deadly force to protect yourself. Now, you can't protect property. Get that out of your mind. You cannot protect property. You got to let them, if they steal your car and they're driving down the driveway, you got to wave at them. That's all you can do. Because if you fling lead at them, you're going to prison, whether you hit them or not. Because you can't shoot at a person stealing your property. That's not allowed in Tennessee.
And I'll tell you, I was just talking to my local district attorney here, and he had a case just like that. And let me tell you about this case, and then I want you to go over the 5 places. So there was a guy stealing his car out of his driveway, and he walked out on the porch with his rifle. And this guy put a lot of rounds through his rifle. He loved to target shoot. Very good shot. And so that guy just, I guess, flipped him off or waved at him and started driving out of his driveway. This guy proceeds to shoot all 4 tires out of his own car to keep the guy from stealing the car. The deputies show up. He is arrested for attempted murder.
Yep.
The DA said, I did not want to press charges on this guy because I knew him. Again, that discretion. He said, I knew he was a dead-eye shot, And I knew that if he'd meant to kill that guy would have had a hole in his head. But he didn't. He just shot his own his tires out of the vehicle to keep the guy from stealing the car. But he said, but by state law, I had to press charges against him, hoping against hope that he wouldn't lose. This goes to trial, and the jury finds the guy not guilty. But so here's the thing that people don't understand. Just because you're like, yes, well, the Supreme Court has ruled the 4 cases, the 4 pillars that you talk about. And I'm like, yes, it is constitutional for you to carry a firearm. It's probably constitutional for you to shoot the tires out of your own car. But that does not mean that you will not be arrested. And it does not mean that you will have to spend $200,000 or $300,000 to defend yourself and then pray again. Here's the discretion of 12 more people that have to say this guy was not trying to murder. He was just trying to shoot his own tires out. He finally got off, but you can understand this guy's life has changed forever.
Oh, yeah, absolutely. It'll drain every dollar you've got. Your wife will leave you. You'll lose your job. And they don't care. And the way the legislators got it set up, they like that because they've got that power. You need to understand, this is the simplest thing that I can try to get across to people. They have delegated powers that we give them. They have moved that needle so far and for so long with no repercussions that they do anything that they want to. There's a person in leadership in the House that explained to a freshman House member 3 years ago when he first came in, he said, boy, we can do anything we want to. If we can get the governor to sign it, we can pass any bill that we want to, and it becomes constitutional until some busybody Nancy spends a couple of $100,000 in 10 years going to court and getting it thrown out. And we get to enforce that law until such time. That is the mindset of the General Assembly. Don't kid yourself. Now, what you're talking about in that instance is they're going to have to arrest you because you broke their law. The DA is going to have to charge you, and unless he uses his discretion and then possibly takes a hit from his buddies in the DA's conference to go, wait a minute, no, you can't do that. Now, some of them have got some strength of will, and they will do that, the good ones. The others, I've got 2 different cases on 2 bills that were run through the House and the Senate, one in 2022 and one in 2025. The bills are exactly the same. And what it talked about is the use of deadly force in defense of property. And so we had a Mr. Northcutt, who is a DA from over in Coffee County, I believe, and he testified for the DA's conference in the committee hearing. He said, the reason that we've had such good results with our laws here in Tennessee, we follow the biblical principle, and we don't feel like a person's life is worth anybody's property. You can't do it. Now, they talked about the 5 areas where you could, and let's go over them real quick.
Yes.
Your home, inside, they talk about in Tennessee, we got a castle doctrine. We do not. We have a you don't have to retreat doctrine. And they like to call it castle doctrine, but we don't have a castle doctrine. But anyway, your home is one of those 5 places. Your dwelling, and that can be your tent or your camper or anything that's on a set of wheels, or you can pull on a sled and get away because it's not your home, right? But it is a dwelling. It's a hotel room or
your
a tent
apartment,
or a camper.
your hotel room, your Airbnb,
correct.
Anything like that.
So those are 2 places.
Legally, where you have to be there legally. That's also part of it.
That's correct.
Right? Yes.
Well, in any instance for you to use a firearm, you have to be in a place that you have a right to be.
Yes.
All right. And you can't be involved in any criminal enterprise, or you don't have the right to self-defense at that point. But that's neither here nor there. So we've got those 2 places. And now the third one is the curtilage. And most people don't understand what that means. And I spend a lot of time asking DAs and asking defense attorneys and asking judges what that means. And it's ambiguous at best. But it's the area around either your home or your dwelling that you customarily use to inhabit that place. So that's your driveway. That's your garage. If you customarily go in your garage, that's part of your curtilage. Your backyard is part of your curtilage.
What's that word again? And does all of your property count? Let's say you got 100 acres. Does all of that count?
It's the area that you habitually use. So by habit, you go there every day.
And what's that word again?
Curtilage. Don't
Cartilage.
you love the way they do this stuff? It just,
I
they
do,
make
yeah.
it so difficult. All right. So you got those three now. We got your home, your dwelling, and the curtilage around them. The fourth is your business. If you're an independent business person, you've got a business, you can carry a firearm inside that business. You don't have to have a permit for that. The fifth place is inside your vehicle. You need to understand that's inside your vehicle. So that's where the window goes up and down. That's inside your vehicle. If a person reaches through that window, he has violated the castle, supposedly, doctrine there, but he's inside your vehicle. In all of those 5 places, you have the presumption that a person that enters that intends to do you harm. Okay.
Gotcha.
You don't have to ask, you don't have to ascertain, and you don't have to leave.
Okay. What if you put the muzzle of your pistol 1 inch past where the window raises?
Nope. Not on that vehicle. You can't do that. No.
That's a problem. Okay.
Yeah. Now at a home, and people say, well, they tried to pass a law last year. One of these less than really sentient individuals from Memphis, who's a Democrat, tried to carry a law last year that allowed you to shoot through the door. And we tried to explain that may be a police officer knocking on that door instead of a criminal, especially in Memphis. It might be. So no, you don't need to be able to be getting off scot-free by shooting through a door. You need to, again, determine whether your life is being threatened by a person who doesn't have a right to be there or is not a police officer. And so they were able to quell that bill. Now, in this year's, I told you what the gentleman said in 2022 when Rusty Grills carried that bill about, and here's the thing, so that we all understand this. Rusty's a farmer, right? He's got these big John Deere tractors or International Harvest tractors out there that cost $1 million a piece. Yep. And so if you got a guy that's out there setting fire to your barn and going to burn up your tractor, wouldn't you think that would be important to be able to stop him from doing so? Or if he's got your prize bull out there loaded up in the trailer and he's fixing to drive off something you got $500,000 invested in, wouldn't you think that that would be necessary for you to be able to protect that from happening? He carried a bill that said you can, in fact, in Tennessee, use deadly force or the threat. People need to understand that the threat of deadly force is the same thing as shooting that person. That you're going to go to jail just because you pointed that gun, whether you shoot him or not. They can convict you of the intent to commit a deadly act, and you'll go to jail for that. Now, you shoot him 8 times, and there's going to be some civil stuff on the other side of that. Make him a vegetable for the rest of his life. His family is going to get a free ride. But all those things being said, it's a crime for you to threaten to use a weapon. So if you take that weapon out of its holster and you point it at somebody outside your home on that property, outside of your curtilage, and you better be able to prove to the trier of fact. And do you know who the trier of fact is? The jury.
DA and the jury. Yeah.
No, not the DA. He's not the trier of fact. The only trier of fact is the jury, or if in fact you opt out of a jury trial, the judge then gets to be the determining trier of fact. Mm-hmm. And so they're the only people that you can even raise and say, but Your Honor, I had a handgun carry permit. Or jury, I had a handgun carry permit. You got to prove to them, you have to prove there is no obligation on the part of law enforcement or the DA or anybody in the state or the federal government to say, but he's got a defense. He had a handgun carry permit. They're not going to raise that at trial. And the only time it gets to be raised is at trial in front of the trier of fact. And when you listen to the people that sit behind the legislators up there all the time, that's the legal department. They'll go out of session and let's ask the legal department, because most of these legislators hadn't got a clue. I'm surprised they can get from home to up there to be in time for their committee assignments, because they ain't got a clue what's going on. And so they have to turn around and ask another group that we're paying a lot of money. And I'm not necessarily sure that they're on our side, because they also draft the legislation. I have had a number of legislators say, okay, I need you to help me with this. I want to pass a bill that does this and so. And so we give them some ideas and they carry it to the legal department, and it comes back. And instead of it looking like an Appaloosa horse, it's an elephant. It's nowhere near the same thing. But they're the people that we pay because they've got the time in the saddle at law school to decide what's right and wrong, instead of doing what the Constitution calls for. That's not what they're interested in. They're interested in that book, or that group that used to be one book and now it's about 80 sits on the side over there, and you see them run over and grab it and start looking through it every time when they're talking about what you can and can't do. And again, you move to Tennessee thinking that you have liberty and freedom and that there are rights here to use firearms. You don't have any. And in fact, if you take that weapon out and you use it, you had better have a pile of money and good lawyers. And hopefully your wife understands that your entire life is fixing to be destroyed and she hangs with you, or otherwise you're going to wind up in the world. You're in a world of hurt anyway if you ever have to pull the trigger. Let me promise you, you need to be sure you have at least one, if not two different insurances like USCCA, something like that, because you need attorneys right then. And the best advice I can give somebody, if you have to do that, is shut up. Don't talk to the police. If they say, hey, we need to ask you a question, say, look, it scared me to death. I think I'm having a heart attack. I need to go to the hospital. And I'll talk to you when I've got a lawyer present. I ain't saying another word. And my friends that are prosecutors will tell you exactly the same thing.
Yeah. And I know that that's a fact, but you have to understand that just common law-abiding, regular salt of the earth people, that sounds fishy. That sounds like you must have done something wrong if you say, I'm not going to answer your questions. Every good citizen, if a law enforcement officer asks them a question, they answer them immediately and probably say, yes, sir, at the end, because that's what good people do. But you see my point. It feels unnatural. It feels almost dirty. I can just imagine my grandfather, if he had to defend my grandmother and he shot somebody and the cops got there and they asked him a question, you'd have to put duct tape on his mouth to keep him from answering that question. But you're saying that you should not answer any questions if something
absolutely
like that.
Do not. Not until you have counsel. Do not under any circumstances, because now we don't have a rights situation in Tennessee. We have a legal situation in Tennessee. And if you don't understand the ramifications of running your mouth, they got a name for you, and it's called an inmate. Yeah, because you need to understand, we got some great police officers, and I say this all the time.
Yes.
We sleep safe in our beds at night because rough men stand ready in the dark to visit violence on those who would do us harm. Okay. Yes. But again, they carry that chalk and that yellow tape because they're not standing with you. The average ratio of post-certified police officers to citizens in the state of Tennessee at any one time is somewhere around 7,000 to 1. All right. On patrol, outside, in a car with a uniform and a gun on, Madison County, at the best time of day, you're going to have about 4,500 to 1. At 2 o'clock in the morning, it's going to be about 8,000 to 1. Now, what are the chances that with that type of number, that officer is going to be standing right outside your bedroom window when a thief decides to break in? They're infinitesimal. And again, you need to be prepared to support yourself, your family, and to protect your own life. But you better understand the rules. You better know exactly what you can and can't do, and what you better say and what you better not say. And the whole point about police officers is they got 10,000 crimes a month coming at them. Okay. Sure. So what do they want to do? They want to clear that docket. They want to solve cases, and they can talk you in to admitting you did something wrong. So they can put a stamp finish on it and they can go on to the next one. Don't run your mouth.
Yep. So
they say, the old Romans said, first thing we need to do is kill the lawyers. That's all fine and true until you need a lawyer.
Right.
When you need a lawyer, you need one bad.
Absolutely. So what I'm hearing is that you can't even confront an intruder, a robber, a thief, a drug addict. If they come on your property, the only time you can pull a weapon and use it is if you're in your home, your vehicle, in your yard, backyard, front yard, in a domicile like an Airbnb, an apartment, or your vehicle. If they come, but you can't even shoot outside of that.
Nope.
To protect, you have to wait for them to basically be right on top of you, inside your car, in your house, in your front yard, in your apartment, Airbnb. You have to wait for them basically to have their hands on you to be really, really safe and to pull your firearm and to defend yourself, defend
All
your
right,
life.
now let me scare you even further.
Oh, God. It
1966.
gets worse.
Yeah, it gets worse. 1966, James Peach, who was a representative from over in your area,
Yeah,
this Benton
he's
County.
passed on now. I used
Yeah,
to
he
be
had,
buddies with him.
bless his heart, he was a good friend of the TFA. But he asked an attorney general's opinion: is there a right to self-defense in Tennessee? And the answer ought to scare everybody. And nobody knows this. And we've been trying to tell people forever, and nobody wants to listen to us. But what the attorney general of Tennessee came back at that point and said, no, absolutely not. There is no right to self-defense in Tennessee. It is statutory only. And here's how it works. If in fact you are required to save your life or the lives of someone you're responsible for by using deadly force, it is at least at that point then manslaughter. And what you have to do, the individual who exercised that prerogative to save your life instead of give up the ghost to the criminal, you have to go before the trier of fact and prove that you were justified in so doing. Law enforcement's not going to investigate and say, hey, we found out this guy was actually exercising self-defense, because there's no right to self-defense in Tennessee. I can prove this to you in 3 different Supreme Court cases that say distinctly that self-defense is the central component of the Second Amendment. Now, Tennessee doesn't pay any attention to Supreme Court cases because it hasn't paid any attention to Heller. It hasn't paid any attention to McDonald, which said in 2010 that we're tired of these states doing this noise. And so what we're going to say is we're not going to let you be in charge of this anymore. We're going to incorporate the Second Amendment against the states through the due process clause of the 14th Amendment.
Right.
Tennessee doesn't pay any attention to it because they've got the brown shirts and the guns, and they hadn't sent the army in here to force them to do it so far. And they look and say, if California can do it, why can't we? And so you would think that Tennessee is all that, but we're not, because we glom on to the 1870 Jim Crow stuff that says it's a crime. And so there is no right to self-defense, even though the Supreme Court in Heller, McDonald, Bruin, and now Rahimi says that you have an unalienable and indefeasible right to self-defense, that it is the true palladium of liberty. And in any government where they attempt under any color whatsoever of official oppression to deny an individual the ability to carry firearms for his protection of person, property, or against a tyrannical government or an invasion, if liberty is not dead, it is on its deathbed. Now, we've got that from our Supreme Courts, and yet we say
right.
No
so
right
even though the Supreme Court has said that, 3 different cases, that you have the right of self-defense, currently that's not recognized by Tennessee. The only way that, but basically, that there's 2 ways that I know of, and you tell me if there's a third, 2 ways we can correct that. One is somebody like me, if a guy broke in here and he had Nisha, my wife, on the ground, had a blade about to plunge it into her heart, I shot him, that's manslaughter. I'm going to probably be arrested for that. I'm probably going to be charged with that. I'm going to have to then, and hopefully I'll have to get convicted and then appeal that all the way to the Supreme Court. And then if I won that, then the state of Tennessee would have to honor everything that the Supreme Court has said very clearly. That's number 1. Number 2 is every farmer, every rancher, every homesteader in Tennessee needs to start grabbing their state rep and state senator by the lapels with a smile initially and saying, if you don't fix this, if you don't fix it so I can use my God-given right of self-defense, I'm going to fire you and I'm going to send you home and put somebody in this seat who will say out loud, yes, you have a right to self-defense. Is that the only 2 ways we can fix this?
That is correct. And it's sad, but it's a true statement, because what they have done, they have bastardized the Constitution, and we go back to the Constitution as a contract amongst the people, and the government's not a party to it. What they are is they're the hired hands that we need. And so the problem of it is that the average person has gotten lazy. You look at what John Sevier and Isaac Shelby and William Carroll and that group, and Andrew Jackson for that fact, and Sam Houston and all of those guys, David Crockett, they didn't put up that mess. They shot their government when they didn't act right. But what we've done now is we've decided, no, it's okay. We're better than that. We've closeted our procreation and elimination habits. And so we're not animals anymore, even though you and I understand that we've got binocular vision and canine teeth. We are, in fact, predators. The thing that gets me the most when they start talking about defenses for using a long gun in Tennessee, you can't protect yourself against a person, but you can against a predator. Right. So if you've got sheep and stuff and you hear the lambs out there calling at night and you look out the window and you see the wolf in the pen or the bobcat or the mountain lion or somebody's dogs in there eating your sheep at that point, you can run out your back door with the rifle. But if you've got a guy from South America that came across the border illegally and he's grabbing one of your sheep and running out, you can't protect your sheep from that predator, even though we're all predators. So
human beings are the ultimate predator. That's why correct. We're the apex predator on the planet.
Yeah, but see, what we do is our DA's conference looks at this and says, well, we follow the biblical deal that, you know, a person's life is worth more than any amount of your property. That's what the DA testified to. Now, let's go back to this year when Rusty Grills ran that same bill again.
Yes.
All right. He's doing exactly the same bill. Use of deadly force to protect private property. The new DA testifier that came in there, Mr. Crump, Brent Taylor asked him, he said, so let me get this straight. If I'm sitting on my front porch and I got a shotgun and a guy comes on my property, if I get up with that shotgun, I'm violating the law. And he said, no, you're incorrect. And he said, what? That's not how I understand. I said, no, let me explain. If you're sitting on your property and he comes on it and you've got your shotgun with you and you tell him, hey, I'm armed. And if he continues to come, then just let nature take its course. That's the DA's conference saying that. That is absolutely untrue. It's incorrect, and that will put you in prison. But that's what they testified to in committee. And it just blew me away. I about fell off my chair. I thought, how can you in good conscience make that statement? He said, well, you know, you got discretion. And if I was the DA, I wouldn't charge you. Well, I've talked to my DA. So my hands are kind of tied on that kind of stuff. I either follow the law or I don't, because how do I know what your intent was? And so what I have to do is wait till we get to the trier of fact, which is the jury, to make
which means you've got to go through the whole trial and jury process to have your right basically given to you by the 12 people on that jury. So anybody watching this in Tennessee right now, if you have a little farm, you have a big farm, if you're living in an apartment currently, if you didn't know this, what Richard Archie has told you, you should be upset. You should be furious. You should be saying, okay, what do we need to do to fix this? My first question to you would be, who's your state rep? If you don't know the answer to that immediately, you're part of the problem. If I say to you, who's your state senator? And you're like, you're part of the problem. Who's on your county commission? Who's your sheriff? Does your sheriff know you by your first name? Because from what Richard's telling me, you probably ought to have a relationship with your sheriff and most of the deputies, because when they come out there, you're relying on their discretion as to whether you go to jail or not. Who's your
one more hint?
Go ahead. Yes.
When you said call 911, let me tell you what you need to do instantly. And I teach this when I go and speak. You need to tell them exactly what you're going to be wearing and the type of weapon that you've got. Because when that officer shows up out there and it's dark and he's trying to find somebody with a spotlight, you need to let him know what you look like. And hopefully you're dissimilar from the individual that you're confronting, because we don't want Popo to snuff us. So make sure that when you call them and tell them, say, look, I'm going to be carrying a Sig Sauer. I'm going to have on a black shirt and a hoodie, and I'm going to have a flashlight in my left hand. And I'm about this tall, and this is kind of what it looked like. Be specific when you describe yourself to them, because that's very important, because they ain't got no clue who the bad guy is, and you don't want to be mistaken for the bad guy.
Right. And so when they pull up, all they see is a guy with a gun, unless you've described yourself on the 911 call, or unless you know the deputies and the sheriff on a first name basis, and they're like, oh, there's Ken over there. I know him. So should everybody who owns property in Tennessee, should every single one of them be a member of the Tennessee Firearms Association?
Absolutely, because here's the fact. We are the only no compromise gun supportive group in the state of Tennessee. I'm a life member of the NRA. I'm a benefactor member of the NRA, and they can't hit their hiney with either hand anymore. They have gone to Access, and what they do is they send out orange cards to the people that vote against our interest every time, because all they're looking for is access. And I mean, Wayne LaPierre was getting $400,000 a year for his suits, and they weren't doing any work.
We don't know what he was getting under the table.
Yeah. And the difference of it is the board members of the TFA, myself and John Harris, we don't get paid a dime. We don't take any money from the membership. What we do is we support good politicians who could possibly help us with this. We have also now started a 501c3, which is a charity. Our mission statement is simply to sue the state of Tennessee, and we're invested and involved in lawsuits because I don't think we're ever going to talk the General Assembly into doing the right thing. Leadership doesn't want it. The governor doesn't want it. I mean, look at the governor 2 years ago tried to put in a red flag law situation in Tennessee,
right?
Which they in New York State, the most liberal state in the union. They've already gone to the Supreme Court of New York twice and found red flag laws to be unconstitutional. And yet he spent our tax money to have a special session. How much did it cost us? I don't know. But what he was doing was trying to take your rights away from you more than what's already there and using your tax dollars to do it when he knew it was incorrect, knew it would never fly, knew it couldn't get through the Supreme Court. And yet there he was putting that stuff on it. We fought that hard. John Rich was very, very helpful in that. We spent a bunch of money and a bunch of time working on that hard. And so TFA is actually doing the work in Tennessee that should be done. And
so do you think if somebody's a member of the NRA currently, should they spend that money more wisely by joining the TFA? Should they be a member of both? What about the Gun Owners Association, the GOA?
The GOA, Gun Owners of America, they're an excellent outfit. I mean, I know Eric Pratt and those people, and we join them in amicus briefs in lawsuits. They help us with our lawsuits here. They're a really good organization. And so what they're kind of like us. They don't give an inch. And so instead of going, oh, let's go in and get my picture taken with the lieutenant governor that's going to vote against everything that we want, they're in there calling them culls just like we are. And so they're not making any friends, but they're making a good effort is what they're doing.
Right.
A Firearms Policy Coalition's a great group. They actually sued the state of Tennessee over here in East Tennessee, saying that 18-year-olds should be able to perfect a handgun permit and to carry a handgun to protect their life. They sued the state of Tennessee and won, by the way. There is a consent order that our new attorney general signed that said the challenge scheme of Tennessee denying 18 to 20-year-olds the ability to carry a handgun for self-protection or to perfect a permit to do the same is a violation of the 2nd and 14th Amendment. The Department of Safety came back and said, well, they did that 2 years ago, and you rascals ain't passed a rule up here to change it. And so we're going to go back to enforcing what's currently on the books. And we caught them at it, and they would say, okay, well, if you can perfect an enhanced carry permit, we'll let you at 18 carry. That's not what the order said. The order said it was specific. It said that you will allow people under 1351, 1366, and 1307G. And I read that in the GovOps committee. I drove to Nashville to testify, and they looked at me like, we don't care. We're going to do what we want to because the legislature has got the brown shirts and the guns. And they can do whatever they want to. Now,
so
they violated a federal court order to do that, by the way.
It sounds to me like you're encouraging every Tennessean to get involved in state and local politics. It sounds like it's a big deal with regards to the right of self-defense, which evidently at this current time, no Tennessean has a right of self-defense, even though there is a God-given right to self-defense.
That's correct.
How do people need to get involved with this, Richard?
What they need to do is they need to join TFA. And here's another clue that I will give you. Make sure you mentioned something close to it a while ago, but if you don't have the cell number of your House member and your senator, get it. And if they won't give you that cell number, fire them and hire somebody that will, because they're your servant. You don't work for them. Now, people, you don't want to talk to the highway patrolman when he pulls you over and says, do you know why I stopped you? Don't be smart with him, because you ain't going to win an argument on the side. Well, you work for me. That's not the way to do it. But I tell these legislators that because they're not carrying a gun pointing it at me at that point.
That's right. They can't take you straight to jail at that moment.
That's right.
Yes, exactly.
Now, they can pass laws that will make your life unlivable. They can they'll make your taxes go up so much that it squeaks. They can take money away from you for the highway fund and then not fix the roads. They can do all these things, but they're not toting that 357 SIG on their side like highway patrol. So you better be polite to that gentleman. Every time I've been stopped by the highway patrol, I let them know. You don't have to in Tennessee. That's another thing. There is no duty to inform here. You in Illinois and you get stopped and you got a firearm in the car, you got to tell them right then or you're going to jail because you didn't tell them. In Tennessee, there is no requirement. Number one, when they pull you over, they look at your tags. They know whether you got a permit because it's the same cotton picking number. Okay. So before they get to you, they know whether you got a permit or not. So I always roll the windows down, turn the lights on, put my hands on top of the steering wheel. And when they ask me, I've got my driver's license and my insurance card and my registration in my hand, ready to go, where they can see it all, because that's a very dangerous job and I respect them. Yes. I don't want their job. But by the same token, every time I tell them I'm armed, I have a weapon in the car, it's in the console or it's on my hip. And every time the state police have told me, well, if you don't touch yours, I won't touch mine. How about that deal? Yeah. I've had my firearm taken from me by local police officers on a traffic stop before, and then they didn't want to give me my bullets back. He unloaded my 45 and said, well, I'm not going to give you one back with a round chamber. I went, yeah, you are, because I'm going to call you chief because I know him. So what you're going to do is give me my bullets back and watch me reload that thing, because that's how you're carrying loaded, aren't you? They need to understand that I get the fact that all they've got's a job. You know, I've got a job, they've got a job. Their job is dangerous. That's true. So is mine. Driving up and down the road in Tennessee right now is hazardous to your health. There are criminals out here. The Democrats have been letting the illegals come in, all these criminals everywhere. It's a dangerous world. Madison County is a dangerous place. We hear about shootings and stuff going on every day. You got to be able to protect yourself, but you need to know how to do it. You need to know how to stay out of jail, and you need to learn to shut up. Now, when you make noise is with your state legislators. Get that cell phone number and call them. My friend that's going to be up here in Yuma on Saturday teaching a course, Brett Rogers, has got a statement, and it's one of the reasons that I fell in love with the basis of what he teaches. He said, talk is cheap. Do a lot of it. So, you know, it doesn't cost me much to talk. So therefore I talk a lot, but I talk in the right places.
Yes, and you do a lot of talking, but it's very, very useful talking. And I think that more Tennesseans need to listen. If any of you guys watching know somebody in Tennessee, a Tennessee citizen, please share this video with them, because I guarantee you they do not know the invaluable information that C. Richard Archie just passed on to them. If you're watching this on replay, there's a link to the TFA. Please consider becoming a member. I'm a life member of the TFA. I used to be a member of the NRA, but I'm now a member of the GOA and the TFA, and I recommend that you be that as well. Get to know your local sheriff, get to know your deputies, get to know your county commissioners, get to know your state rep and your state senator, and talk to them, call them, email them. If you don't do that, then you're not part of the solution. You're just one of the sheep walking around waiting to be harvested. Am I right, Richard?
You are correct. Let me leave with one last thing. Do you remember the hurricane that came through North Carolina and Tennessee last year and just decimated everything up in the mountains? The reason that we ran that bill again this year for protection of personal property with deadly force, or the threat of it, I was called by a state legislator, and he had been called by a number of people in his district up there that had been accosted by gangs with four-wheel drive trucks that were coming in, and they were stealing what little they had left. And so one of the guys called the sheriff, you know, still had cell service, and he said, I'm fixing to get out there and stop him. He said, you can't. If you do that, I'll have to arrest you. He said, what? And he explained to him, said, you cannot use deadly force to stop those people from stealing your generator or your lawnmower. You can't do that. And so there was such a hue and cry coming out of East Tennessee of people wanting to change that, that I actually had a legislator who characteristically don't talk to TFA because anymore, to tell you the truth, the reason we have a handgun carry permit in the state of Tennessee is in 1994, John Harris wrote the law. He wrote the bill and worked to get it passed. It was may issue at that point. We went back the next year in 95 and got it changed to shall issue. But we used to be accepted at the General Assembly until we started asking hard questions about how come we can't do this and how come we can't do that. And so anymore, what they will tell you is if it's got TFA fingerprints on it, it's going nowhere. So what we have to do is work with good legislators, and they ask us questions, we answer, but we don't ever put our name out there as supporting a bill by TFA. However, what we will do is give you a report every week during the session to let you know what's happening. You can prescribe to an email from TFA that will let you know every bill that's on notice, who's for it, who's against it, whether we're for it or against it, and what needs to happen when it comes up before committee. All those different things are there if you want to take advantage of them. But there is no right to protect your property. And so those people in East Tennessee who were so incensed about that are still incensed about it because our General Assembly did nothing to help them in that situation.
Yep. And let's just be very clear. Somebody stealing your generator in that situation, that's literally life or death.
The way I parsed it, and of course, Brett Rogers will tell you the thing to do is to tell a story. Okay. You want to get somebody's attention. So you got an individual living up in those mountains that during the wintertime, we know it snows and you can't get on the road. But a family member, a loved one, is doing dialysis and they've got a home dialysis machine. Now, also, the power goes out up there quite a bit because of the snow load and all this kind of stuff. So you've bought that whole home generator that cost you $30,000 to put in. And so when the hurricanes came through and the guy is loading up your generator, the bridges are out, you can't go anywhere, but you still got that generator fuel with diesel up there. And when they pulled in that group of Venezuelans with those 4-wheel drive flatbed trucks and started loading that generator up, his loved one's life is at danger. And what they say is that imminent death or serious bodily injury is a reason to be able to protect yourself by using deadly force or the threat of it. Could that be construed then? And that legislator that I was talking to said, you know, you make a compelling argument, but he didn't have the strength of will to go up there and testify for that bill. He let somebody else carry it. He refused at the end of it, say, even though I wanted you to do it, I don't want to carry it. Probably better somebody else. They're all a bunch of culls up there. We've got a few that are good and the rest of them are cowards. And what they need to start doing, and people go, man, you're just making enemies. No, I'm just telling the truth is what it is. I wish we could make them put emblems on their jackets like NASCAR to tell you who pays them to do what they do. Because it's not the average citizen up there. It's more the Chamber of Commerce and the Lawyers Association and the insurance companies and Farm Bureau and people like that they listen to instead of the general population. And by the way, they will say, well, I'm going to do what my constituents won't know. What they need to do is what the Constitution calls for. If they will simply do that, then that would do away with all the rest of this noise.
Yep. Question number one, any elected official should ask is, what does the Constitution say? Question number two is, what do my constituents want? And then a distant third should be, what did the lobbyists say? What did they say? What's the governor think? What's the attorney general think? That should be the third question that an elected representative asks. Shouldn't be the first or the second. And so, Richard, Archie, thank you so much for doing this. I know that you have upset several people watching this. I can tell from the comments because they did not know the things that you have relayed to us today. So I thank you very much for that. And I hope that this lights a fire under any property owner's butt in Tennessee to say, wow, I did not know that. Number one. Number two, I don't like that. Number three, I'm going to get busy changing that, because why would your state rep care about what you say if the lobbyist is taking them out to dinner every day and they never hear from you? Why should they even really care what you say? The only way you're going to get the change you want is to be mouthy, is to show up, stand up and speak up, just like Richard Archie's doing, and I'm increasingly doing myself. Richard, thank you so much for this. We might have to do a round 2 in the future.
All right, very good. I appreciate the opportunity to inform.
Thanks for watching and sharing, everybody. We'll see you next time.